sentencing is still way out of whack with the actual harm done by the particular person accused.
Do you know what your rights are if you're charged with a drug crime in New York City, and where do you turn for help? We're going to get the answers to those questions and more right now, because that's what we're going to ask on Ask the Lawyer on today's episode. My guest is New York City Attorney David Cohen. I want to remind you right off the top, if you want to ask David questions about your situation, it's easy. You can go to AskTheLawyers.com, click the button up at the top that says Ask a Lawyer. It'll walk you through the very simple process there, or you can call the phone number you'll see on the screen during our conversation. David, it's good to see you. Thank you for helping us out again.
Nice to see you, Rob. Thank you for having me.
So we're talking about drug crimes. Let's just talk a little bit about your experience. Is this the sort of thing you've handled, a case or two like these in your experience at your firm?
A few thousand of these, Rob. Yeah, I've been practicing for 27 years, first as a prosecutor and then as a defense attorney. I've represented thousands of people accused of drug crimes, both state and federally, both here in New York and in different parts of the country.
Are we talking possession, sales, conspiracy, all of the above?
Yeah, yes, Rob, that's correct. All of the above. I've represented people on minor drug infractions, possession of a gram or less of various types of drugs, cocaine, crack, heroin. I've represented people's sales of small amounts, sales of large amounts, sales of kilos, importation, both from different parts of the country as well as from countries abroad. We've represented people charged with conspiracies, conspiracy to bring kilos, sometimes from our southern border, other times from the western border. Represented people at trials. I've probably done 50 or 60 drug trials as lead counsel, done them on the state and federal level. So we have a vast amount of experience, and me personally have a tremendous amount of experience representing people accused of drug crimes, trafficking, etc.
So a couple of times you've mentioned the state and the federal level. Tell me what makes a difference. What makes a difference between a New York State drug case or whether it becomes a federal case?
Sure. So a state case is something that happens within the particular state that you're in. In New York State, for instance, we have just over 60 counties. Each county has its own criminal court. And if you commit or are alleged to have committed a drug crime, whether it's possession or sale or even conspiracy in a particular county, you'll be prosecuted by the state in that particular county. Now, federal prosecutions are normally happen when there is an allegation of a crime being committed across borders. From California to New York, for instance, is a common one. From Florida to New York is a common one. Texas to New York is a common one. But even New Jersey to New York and on bordering states as well. But of course, if something comes in from overseas, that's going to be a federal crime as well. Now, interestingly, there are exceptions to that. That's the general rule. But on federal matters, you can be charged, and I have had several clients charged for conspiracy to distribute drugs within one particular state, and that was charged federally. There are certain nuanced laws that happen, and the federal government usually has the last say in whether they want to take on a particular case and charge you federally, or whether they want to leave it to a particular jurisdiction where they can have jurisdiction, they being the federal government, if all of the allegations happen in New York, or they can choose to give it to the New York State prosecutor to charge them locally at the state level.
Is it generally just boiled down to federal charges? The penalties are much more severe and that sort of thing? Is that basically the big difference?
Well, that's one of the differences for sure. In federal court, there are a lot of what's called mandatory minimums, meaning if you are accused of a certain amount of drug trafficking and you are ultimately convicted, then even if you have been living the life of a saint for the first 60 years of your life and a judge wants to give you a probationary sentence or a supervised release sentence, the judge cannot by law give you that. There's a mandatory minimum. Sometimes it could be 5 years, it could be 10 years, it could be as much as 20 years. And regardless of how sympathetic or empathetic your particular case may be, a judge is required to sentence you to that mandatory minimum. In state cases, there's a lot more negotiation going on, and there's the opportunity to plead out to lesser charges and to not face any prison time whatsoever. The federal government has a much more onerous schedule of sentences for those people convicted of crimes. They also have tremendous amount of resources. So almost without exception, one is better off being charged locally at a state level than they are at a federal level.
Is that the kind of thing that a good attorney can help maybe knock something that might have been a federal down to a state level, or is that not, do you not have flexibility there?
Generally, once the feds have decided to pick something up, you're not going to be able to get them to charge you locally at the state level. We have had a number of cases where the state has charged our clients, and then ultimately the federal government, through further investigation, has determined it was a federal case. I have a case now where a client was charged in 2 counties in New York State with drug trafficking, and he was arrested in both of those counties and charged in both of those counties. Both were legitimate state prosecutions, but because the federal government made a charging determination that my client was not acting alone and that there were other people involved, and they made a determination that it affected interstate commerce, they took over the case. The benefit to that is once the feds charge you for the federal crime, the state will not charge you for those same acts. The big concern, as I said previously, Rob, is whether the sentencing is much more severe in the federal case versus the state.
You mentioned, you alluded to this a little bit ago, but when someone's charged with a drug crime, David, whether it's state or federal, does their past criminal record or lack thereof have bearing on how things might go for them?
Certainly. There's 2 ways that we look at a past criminal record. One is obviously in the negotiation with the particular prosecutor on the matter. Somebody who is charged and they're 45 years old and have never been convicted of a crime in their life, much less a drug crime, is now being charged with some massive conspiracy, and maybe they are considered a minor player in that, and the federal government doesn't have as much evidence or alleged evidence against them. Somebody who has never been convicted or even charged with a drug crime, you have a stronger argument that what the government has or their allegations against them are not as strong as the government may initially believe, right? To be charged in a conspiracy is a scary thing, a drug conspiracy. You could have made one drug sale or to have alleged to have made one drug sale, but the people that were dealing you those particular drugs or selling them to you may be involved in a much bigger conspiracy. And legally / technically, you can be charged in the whole conspiracy. It gives us, as a defense attorney, the ability to argue less responsibility if there is no prior conviction. Now, that being said, with a prior conviction doesn't mean that you did anything wrong, not at all. A prior record of drug possession may undermine an allegation of drug sale. Oftentimes, we can frame arguments that our client was a possessor or a user and not a seller. And the particular consequences for being a possessor or user versus seller are drastically different. Not only are the sentencing charts different, but the way the prosecutor will look at you is different. That's one area the prior conviction makes a difference. The second area that most people are concerned about is in sentencing. Sentencing is enhanced when you have a prior criminal record. I spoke previously about mandatory minimums. Mandatory minimums can go up when you have a prior record. In federal court, your sentencing guideline, which is the suggested sentence for someone convicted of a similar crime as you, gets higher if you've had multiple convictions. So to simplify that, or even one conviction, to simplify that, if I am charged today with a drug sale of X amount of drugs, and I have a co-defendant who's charged right along with me with the same facts, but he has 4 prior drug convictions, the sentencing guideline in federal court would suggest that my exposure should be much less than my co-defendant's exposure, even though we did the same exact acts because of his prior record. So in terms of sentencing, a prior conviction or a prior record could and oftentimes would enhance what the government's recommendation is at a sentencing state. And the last part of that is on the state level, where a prior conviction may in certain instances mandate that you get a higher sentence than someone who has no prior convictions.
We're seeing all over the country, David, seems to be in many states a different attitude towards drug use, at least as far as marijuana, and many states have legalized recreational use of marijuana. In your experience, are you seeing that change of attitude as far as when it comes to other drug crimes, as far as sentencing and convictions and that sort of thing, or is it not filtered down that way?
Well, I think we have seen a change over the last several years. For instance, on the federal level, it used to be these suggested guidelines I'm speaking about were not suggested at all. They were mandatory. So a judge was required to sentence you to what the suggested guidelines were posited by Congress. And in New York, we used to have this 3-strike rule, right? The Rockefeller drug laws, where the sentencings were just outrageous. I do think that the legalization of marijuana, both medicinally and recreationally, does affect law enforcement's view toward minor drug crimes. So I think that there is somewhat of a trickle-down effect. Marijuana is, at least in New York, while it is a crime for certain levels, rarely do you see anyone arrested for that. And I can't remember the last time that I saw someone at that state level go to jail for any level of marijuana possession. I think in general, you're seeing a little bit of a reduced or a relaxed attitude towards certain drug crimes, not as much as we in the defense bar believe is appropriate, because oftentimes drug possession is a sign of an illness or an addiction, and the sentencing is still way out of whack with the actual harm done by the particular person accused.
Lots of interesting information, David. Thank you for making some time to answer our questions. I appreciate that.
Thank you as always, Rob.
That's going to do it for this episode of Ask the Lawyer. My guest has been New York City attorney David Cohen. I remind you, if you want to ask David questions of your own, go to AskTheLawyers.com. Click the button up at the top that says Ask a Lawyer, and it'll walk you right through the very simple process right there. Thanks for watching. I'm Rob Rosenthal with Ask the Lawyers.